Yes, hello everyone, and thank you for joining my colleague Anke Saßmannshausen and of course from the US, Alec Bandza of Barnes and Thornburg, and myself for today's ESG session. Anke and I are lawyers of the commercial practice group of Fieldfisher in Hamburg, Germany, and about a year ago we already held this webinar primarily giving an overview on the newly enacted German Supply Chain Act. And today we would like to give you an update. Policies and laws have on governing supply chains remain an important topic. And the breaking news, of course, being that last Friday, a revised text of the European Corporate Sustainability Due Diligence Directive, which I will now refer to as CSDDD, it's a long name, was endorsed by the European Council, so that after weeks of uncertainty, new EU rules on sustainable supply chains are likely to pass into national laws. Generally speaking, the aim of the CSDDD as well as of the German Supply Chain Act is to make globalized supply chains socially and environmentally sustainable and anchor human rights and certain environmental considerations in companies' operations and governance. But now let's first take a look at today's agenda. Anke and I will give you a quick overview on the German Supply Chain Act, and we'll then talk about the CSDDD and finally about some new upcoming ESG legislation in Europe. Well, first of all, I'll now start out with the German Supply Chain Act. And just very briefly, the German Supply Chain Act has been enacted at the beginning of last year in January after long legislative procedures and considerations. And this was an important milestone in continuing the trend of ESG legislation, and will also impact or has also already impacted markets beyond Germany. The Act obliges entities falling within the scope to adequately comply with human rights and environmental due diligence obligations in their supply chains. And yeah, the question is, what companies fall within the scope? What entities are captured under the German Act? And it was a staged approach. So in the beginning, last year, the Act applied to companies with 3,000 employees in Germany, and it now dropped down, the threshold dropped down as of January to 1,000 employees, which must be located in Germany. The company must be headquartered in and have its administrative or seat or corporate seat in Germany, or it must be a German branch office of a foreign entity. And there are also some attribution mechanisms in place as regards the headcount when it comes to group companies of affiliates. So these are also taken into consideration. Even if your company is now located outside Germany or has a lower headcount, the Supply Chain Act will still have an impact on your company if it is the contractual partner of an in-scope company. So in other words, of a large German enterprise as a customer, for example. This is why it's important to get familiar with this law and also anticipate that German in-scope customers will require ESG-related information and impose certain safeguards as conditions to do business with them. So for example, maybe you have come across self-assessment questionnaires. This is a typical example. So this will obviously be a good preparation for the upcoming EU directive. The German supply chain is defined in the Act as as referring to all products and services of an enterprise and including all steps in Germany and abroad that are necessary to produce products and also provide the services. So it's not just covering goods, but also services, and it includes actions of an enterprise in its own business area and as well actions of direct suppliers and to a certain extent even to indirect suppliers. In any case, as you see, the definition only refers to the own business area and upstream supply chain. And yeah, this is different under the EU law. Next, we will take a look at the protected legal positions within a supply chain, which are formulated as prohibitions in the German Supply Chain Act. The Act refers to various international conventions enshrining human rights, and the protection of human rights in the supply chain is certainly the main focus of the German Act. And there are three areas in this respect. One is the protection of employees, covering the prohibition of forced labor, slavery, child labor, and also unequal treatment. Also, this covers fundamental employees' rights, as for example, the freedom of association, to name just a few. And then other areas are, for example, protection of natural resources, and there's also a category regarding protection from security forces, which is about the prevention of violence. Then environmental concerns are only protected to a limited extent under the German Supply Chain Act, particularly where environment-related risks lead to human rights violations and where certain chemicals and substances become hazardous to people and the environment. The environment-related obligations stem from three international conventions, and this is one is the Minamata Convention dealing with the prohibition of mercury-added products and use of mercury. The next is the Stockholm, or also referred to as POPs Convention, which is dealing with the production and use of persistent organic pollutants, as well as the Basel Convention regarding bans on export and import of hazardous waste. The climate protection and decarbonization is not yet covered by the German Act, but this will be the case under the EU directive. Human rights and environmental risks shown in this overview are prevented and minimized through compliance with the due diligence obligations. And this is also the core piece of the German Supply Chain Act. And we will therefore now dive into the due diligence obligations, and I will give you a brief overview. These are primarily, the due diligence obligations primarily, of course, affect only companies which are directly in scope companies. The first obligations are the requirements to set up a risk management system and carry out a risk analysis. The establishment of adequate, effective risk management requires, among other things, the designation of a person who's responsible for monitoring the risk management. And the Act suggests to appoint a human rights officer. And as part of the risk analysis, enterprises have to identify, weigh, and prioritize risks in their supply chains. And this has to be reviewed, the analysis has to be reviewed on an annual basis and also on ad hoc basis in case of any incidents. Companies need to establish a clear policy statement also on their human rights strategy, outlining their commitment to human rights and environmental issues, and specify in particular the risks identified and how a company is going to address them. And this can be, for example, done or also be reflected in a code of conduct. And the policy statement and codes of conduct normally also define expectations a company has towards its own employees and suppliers. In case risks are identified, companies must implement a risk-based preventive various risk-based preventive measures, and these are adapted to the type and level of risk. In a company's own business area, this, for example, to just give a few examples, would include suitable procurement strategies, purchasing practices, training, and risk-based control measures. And with regard to direct suppliers, the expectations are normally also taken into consideration in the selection process. Then next, remedial action must be taken in case violations are discovered or imminent. And in its own business area, a company must eliminate violations, but a termination of a business relationship with a direct supplier is normally only required in exceptional cases as last resort. Action must also be taken regarding indirect suppliers where a company gains substantial knowledge regarding a violation. But it is still important to note that's a main principle that there is no obligation to succeed, but only an obligation to make an effort and comply with the duties in an appropriate manner. This means that in-scope companies are not obliged to prevent violations outside their own business area by all means, but rather to determine on a case-by-case basis which measures are appropriate and reasonable and can be expected of this type of company. Also, another requirement is a complaints procedure that a company falling within the scope must have in place, enabling internal and external stakeholders to notify violations, and the rules must be made publicly available. And all due diligence obligations described are flanked by reporting and documentation obligations. Covered companies must annually submit a report to the supervisory authority, which is the Federal Office of Economics and Export Control in Germany, called BAFA. This is it in a nutshell. And now my colleague Anke will take over to explain to you on how cooperation in the supply chain can be achieved and what is to expect when doing business with in-scope companies in Germany.
Yes, thank you very much, Sarah. Let's now take a look at how the due diligence obligations from the Act have actually started to affect the cooperation in the supply chain. In particular, if you work for a US company or other company that is not itself an addressee of the Act, you may have already been confronted with requests from your German customers targeting at the compliance with the Act. As a first step, we see that companies are increasing their efforts to perform initial due diligence on their suppliers before starting new business relationships, and also extending their ongoing due diligence procedures with existing suppliers. For example, many companies require their suppliers to provide self-assessment questionnaires, which touch on the requirements of the Act. There is also a variety of tools provided by third-party service providers to help in this process. Such due diligence procedures are part of the risk analysis, and we expect that the use of questionnaires and tools will be standard for future supplier relationships, regardless of whether or not customers are directly affected by the Act or other ESG legislation. As many end customers expect enhanced efforts with regards to the sustainability commitment of manufacturers, customers will require more information of the circumstances at the level of their suppliers. Just to name a few examples, the scope of the supplier questionnaires is likely to cover information on the structure, stakeholders, branches, and risks within the supplier company. As a next step, addressees of the Act must obtain so-called contractual assurances from their direct suppliers that they will comply with the customer's expectations and, furthermore, that they will address such expectations appropriately along the supply chain. The exact scope of such contractual assurances depends on the results of the risk analysis. The BAFA, as the competent authority, has stressed that blanket and overly far-reaching obligations must be avoided. If you are confronted with compliance obligations resulting from the Act, we therefore strongly recommend to have them checked from a legal perspective and to challenge any clauses which are overly far-reaching. So what exactly can you expect German customers affected by the Act to include in their contracts with their direct suppliers? First and foremost, contracts will aim at the prevention of violations of the protected legal positions. To this end, suppliers are often required to comply with the Supplier Code of Conduct, and companies will likely ask for certain flexibility by adding a right to amend such code as need be. For example, if the underlying risk analysis has changed or in case of regulatory updates. As preventive measures, companies may also request their suppliers to purchase certain products only from selected and previously audited sub-suppliers or ask for certain product certifications. In addition, training obligations and control mechanisms, such as on-site inspections or audits, can be stipulated in the contracts. Companies may also ask for appropriate remedies, which take effect when there is a violation of a protected legal position or when such violation is imminent. In particular, a joint plan to end or minimize the breach has to be established. If necessary, the customer may join forces with other companies as part of industry initiatives to increase its influence on the supplier. It may even be appropriate to temporarily suspend the business relationship so that the contract should provide for suspension and termination rights for such cases. However, termination of the business relationship is only necessary as a last resort if the violation is very serious and milder means are not available. Finally, contracts may establish an obligation to pass on the duties relating to human rights and environmental risks to indirect suppliers. In other words, if you are a direct supplier to a customer subject to the Act, you may be required to adjust your own contracts with your suppliers in order to be compliant with your obligations toward your customers. However, as previously mentioned, it is absolutely advisable to run a sanity check on the obligations your customers want to impose on you. If such obligations go beyond the scope of what is actually legally required, such obligations may potentially be considered void in accordance with German statutory law regarding standard terms and conditions. This depends on the results of the underlying risk analysis and the design of such clauses, and should therefore be assessed on a case-by-case basis. In particular, as we have already mentioned, the BAFA has published a guidance on the collaboration in the supply chain. While many advocacies, and in fact also the template contracts available in legal databases, initially tended to provide for rather restrictive provisions on their suppliers, the BAFA as a competent authority has clarified that it expects a cooperative approach and that the advocacies of the Act must not fully delegate their due diligence obligations to their suppliers. In the end, it's a customer's responsibility to implement its due diligence obligations. The BAFA emphasizes that building capacities at the suppliers should be prioritized over ending business relations, which may also create opportunities for suppliers to negotiate favorable prices, supply times, and conditions. As regards fairness in the supply chain and the underlying goal of ESG legislation, it is also interesting to note that there are ideas to widely rethink contractual mechanisms to make them more responsible and less likely to contribute to violations of human rights and the environment by the concept of responsible contracting. A prominent example are the European model clauses, which are currently being drafted by the European Working Group of the Responsible Contracting Project, in particular in light of the German Supply Chain Act and the European CSDDD. Finally, before Sara will report on the status quo of the CSDDD, we have pulled together some useful resources about the German Supply Chain Act in English language. In particular, if you're confronted with requests from your customers, which you are not sure how to respond to, it may be helpful to check the guidance published on the collaboration in the supply chain, which also includes links to other BAFA guidances, such as the guidances on risk analysis, complaints procedures, and the principle of appropriateness. Now Sara will continue with the overview on the
this is an exciting topic because last year we only gave a quick outlook on the EU legislation, and this was and right before this webinar, we thought we would have a totally different situation because it was after a big struggle. We didn't expect that the EU CSDDD would go through past the legislative process, but now, well, I better start from the beginning. The initial proposal was made by the EU Commission in February 2022. And following this, there were extensive negotiations between the European Commission, the EU Council, and the European Parliament. And a provisional agreement was reached in last year, December. And this was criticized as not going too far enough by human rights and climate groups on the one hand. On the other hand, the industry feared additional bureaucracy and also rejected the civil law liability as excessive. So when nobody expected this, in January this year, Germany caused an unexpected turnaround, which led to a firm opposition of the directive also by other countries. And after weeks of political struggle, the EU Council was finally finally endorsed the CSDDD last Friday, which came a bit unexpected. And this vote was really crucial because it was the last opportunity for the directive to be adopted in its current form before the European parliamentary elections, which are taking place in June and where a majority vote is now expected. But it must be noted that the final text approved by the Council is a heavily watered down version of the original and the earlier proposals, in particular as it covers fewer companies and activities and also provides for a more gradual phasing in period than originally envisaged. And I will now briefly explain to you the content of this last-minute compromise. Officially, the text of the directive is not publicly available, but has leaked through unofficial channels. So, of course, we are not absolutely familiar with all details, but we can explain to you the its main characteristics. And yeah, the overview. Well, first I will start by explaining what the supply chain is, or how the supply chain is defined in the CSDDD. It's referred to as the chain of activities, and different from the German law, this covers the activities of a company upstream of the company's upstream business partners related to the production of goods and provision of services, and also activities of a company's downstream business partners related to distribution, transport, and storage of a product, where the business partners carry out such activities for the company. And there are certain exclusions, but the definition of the supply chain has been narrowed down after the latest changes, and downstream it only applies, the application is limited to direct downstream business partners to whom a company is contractually bound. The protected legal positions do not only include human rights, but to a greater extent also cover environmental impairments and the combating of climate change. I will now give you an idea of the scope of the European directive, as well as the due diligence obligations and liability and sanctions in the next slide. The newer version of this directive has been significantly, this latest version significantly narrows down the scope, now almost excluding 70% of companies which were originally covered in the first draft. And originally the CSDDD impacted companies with 500 employees and a turnover of 150 million. And the new deal also now removes the high risk sector approach, which was included in the initial drafts, which included companies irrespective of the headcount that operate in industries with a high likelihood of facing human rights and environmental issues. Now, a phased-in implementation based on the size has been introduced, allowing a progressive application. So ultimately, after 5 years in 2029, companies with more than 1,000 employees and a turnover exceeding 450 million will have to comply with the directive's obligations. And also, this is important to note, also non-EU companies which are not formed under any EU jurisdiction must comply with the CSDDD if they generate more than 450 million of net turnover within the EU, within 2 consecutive financial years. In the initial phase, after 3 years, only companies with over 5,000 employees and a turnover exceeding 1.5 billion will be captured. And then in the next year, the threshold will drop down to 3,000 employees and a turnover of 900 million. So as you see, only very large companies are covered. Companies must comply with a number of due diligence requirements to address adverse impacts on human rights and environment, putting into place governance structures, identifying and assessing risks, preventing, ending, and minimizing any violations. They must also evaluate the effectiveness of their measures and provide remedial measures and implement a complaints procedure. So very generally speaking, it is quite similar. The due diligence obligations are very similar to the German Act. But what is new is a specific civil law liability is established in the European directive to permit third-party claims against companies for non-compliance with critical provisions. To establish liability, intentional and negligent failures must be demonstrated, and these must result in damages to legally protected interests. However, a company can only be held liable to a limited extent if the breach was caused by its business partners. Then, as regards sanctions, the EU members, this is up to the EU member states, but they will be required to have penalties in place and a maximum penalty which shall not be less than 5% of a company's worldwide net turnover. This shows that even though fewer companies are in scope as regards the relevant thresholds than under the German Act, the EU regulations are further reaching, which I will show on the next slide, which serves as an illustration. So you can see the difference between the German Supply Chain Act and the European directive. The main difference is, of course, the scope of application. The threshold under German law is a bit lower and not linked to turnover, but only headcount. And also all types of legal entities are covered by the German Act, whereas under the EU legislation, only certain legal entities, corporations mainly, fall within the scope. Then under the EU directive, this is further reaching. It's not just the upstream supply chain that is covered, but also the downstream supply chain. And the protected environmental positions are limited under German law, and this is far more extensive under the European directive, especially since now also the combating of climate change and decarbonization is covered by the directive. Then also this was especially criticized by Germany. A special civil law liability is established by the EU directive for companies in breach of their obligations, different from the German Supply Chain Act. And also there is under the EU directive, there is no cap for fines and penalties under the directive, which only states that the maximum a maximum of shall be not less than 5%, but there's no number as a cap. Despite the long implementation periods under the staged approach, lessons learned from the German Supply Chain Act teach us that businesses that will be directly in scope should plan way ahead and also look into the relevant topics in advance. And companies which are only indirectly affected, as they are not, for example, where they are part of a supply chain of a bigger in-scope company, will still need to comply with some requirements. As Anke already mentioned, obligation will flow down through the supply chain. And this is not in this respect, there is no difference to the German Act. This will also be the case for the EU directive. The CSDDD is, of course, not the only new ESG-related legislation, but a number of new EU, particularly on as part of the so-called European Green Deal, laws have been initiated or are on their way, and my colleague Anke will now outline these for you.
Yes, thanks. So what else to expect from upcoming EU ESG legislation? While there were numerous new laws and regulations at the national levels within the EU, the European legislator has also been quite active. Just to name a few, first of all, there is a CSRD, short for Corporate Sustainability Reporting Directive, which replaces a non-financial reporting directive, under which in Germany around 500 large capital market-oriented companies, as well as bank and insurance companies, have been obliged to prepare a so-called non-financial statement since 2017. The CSRD applies gradually as from 2024 for reports to be published in 2025 and widens the scope of companies obliged to issue sustainability reports. The CSRD applies to all listed companies as well as large companies which fulfill the two following criteria. More than 250 employees, a total balance of 25 million euros, or a net revenue of more than 50 million euros. As from the financial year of 2028, companies from non-EU countries with a net turnover of more than 150 million euros in the EU will also fall within the scope of the CSRD if they have at least one subsidiary or branch in the EU and exceed certain thresholds. In the area of sustainable finance, there is the taxonomy regulation with the obligations to report on sustainable investments in portfolios of financial market participants. In addition, the sustainable finance disclosure regulation covers sustainability-related disclosure obligations in the financial services sector with regards to strategies, processes, and products. Furthermore, the benchmark regulation has been revised to add sustainability-related information for financial benchmarks. On a product-related level, there is a proposal for a directive on the so-called right to repair, which shall promote the repair of consumer products. Sellers of consumer products shall be required to offer the repair of the product during the warranty period if the repair is cheaper or as expensive as a replacement. It shall further remove obstacles to repair products outside the warranty period. Furthermore, there is a proposal for the so-called eco-design regulation, which aims at setting forth specifications for the resource-saving manufacture of products and the extension of product lifetime or product service life. While the previous eco-design directive only applied to energy-related products, the scope of the new eco-design regulation shall now cover almost all categories of physical goods which are placed on the EU market and has therefore a very wide scope. With respect to marketing, the legislator aims at banning greenwashing, namely the so-called Green Claims Directive, a new directive banning greenwashing and misleading product information, shall implement a ban on claims regarding the climate neutrality of products through offsetting measures, establish strict requirements for advertising with future environmental benefits, and put a ban on non-state certified sustainability seals. So it's definitely worth to stay tuned on the regulatory environment in the EU, and the same is true for the other side of the Atlantic, which is why I am now pleased to give the floor to Alex Bandza to report on the latest developments in the US. Thank you.
Thank you, Anke, and thank you, Sara. Hi, everyone. My name is Alex Bandza, and as mentioned, I'm a environmental and energy partner in the Chicago office in the US of Barnes and Thornburg. And I think a reality that all of us had faced is we put the presentation together, and then of course we get news just days before we actually give the presentation on things that have changed. So certainly a fast-moving area. And appreciate the chance to give you a bit of an update. And so what is probably of most interest and what I'd like to focus much of my time on is the Securities and Exchange Commission came out with finally their rule with respect to climate related financial disclosures under the security laws. And if we have time, want to touch on a couple other pieces which I think combined illustrate that this is not solely a public company kind of issue in the US, but there's a lot of different pieces of legislation and regulation that may pull in broader nets of companies, not least of which companies with international operations that may start being subject to the EU and German topics that were just discussed. Next slide, please. So a quick overview before we jump in to the specific regulation. The securities laws in the US target public companies or reporting companies, and these are companies that are subject to reporting requirements and must file certain reports annually, quarterly, with the SEC on an ongoing basis. A company can become a reporting company in one of two ways: by issuing securities in an offering that's registered with the SEC, or by registering a class of securities with the SEC. And so a couple of pieces of, I guess, acronyms that we'll see a few different times in this presentation. So there's the existing regulation, SK, which, as I've put on the slide here, is broad as currently written, and a couple of topics or hooks, so to speak, where some of the climate-related provisions arguably may fall into or be fleshed out later. So here we have, for example, the first one with respect to compliance, anything with a material effect on compliance with federal, state, or local provisions that may have on the registrant, quite broad. With respect to human capital, description of the business and human capital resources that are material to understanding the registrant's business. So this is maybe the S and G side of ESG. Legal proceedings are broadly defined under the existing regulations to be material, and they specifically include environmental proceedings. And then as lawyers love, a good catch-all, so risk factors, including significant factors that may make an offering speculative or risky. So the current landscape, or the landscape before the rule that I'll jump into, has many of these broad requirements that I think, as we will see, become further refined with the climate-related rule. Next slide, please. So just almost 2 years to the day, March 21st, 2022, the SEC proposed rule amendments requiring public companies to include certain climate-related disclosures in their public disclosure filings. This proposed rule was based in part on the Task Force for Climate-Related Disclosures, TFCD. One of the biggest issues out of the gate was whether what are called Scope 3 emissions would be included as part of the scope, so to speak, of the SEC climate rule. And so briefly, emission scopes are categories of the sources of GHG emissions generated by companies, and they're typically divided into scopes 1, 2, and 3. They provide a measurement criteria to evaluate GHG impacts and a quantifiable basis to serve as a benchmark for GHG reduction goals. So scopes 1 and 2 are emissions that are directly attributable to company operations and can be measured with usually data that's easily accessible to a company. Scope 3 emissions are sort of everything else. So they're a result of activities from assets not owned or controlled by the reporting entity, but that indirectly involve the value chain or affects the value chain. So one of the examples where this can come to light is something such as the oil and gas industry, where there's going to be emissions associated with the production of fuels or petrochemicals, but the scope 3 downstream may really dwarf so the actual consumption of fuels and petrochemicals from just a GHG basis. So this was really a lightning rod of, I guess I could say, many lightning rods of interest as part of this proposed regulation. And so unsurprisingly, there's been indications this was a record-breaking number of comments that were submitted on the SEC climate rule, almost 30,000 comments. A lot of these are form letters, but the SEC identified that were 4,500 unique, specifically written letters. All of them each going to have their own different takes and criticisms, and that on balance, the SEC must respond to as part of its latest rulemaking. Next slide. So, literally 2 weeks ago, the SEC issued its final rule, a modest 886 pages for your perusal. Everyone is sort of digesting what's different, what's new. I'll get into some of the legal challenges, but the chatter surrounding this is there's certainly a lot to talk about and a lot to unpack. And so before getting into a few more specifics, wanted to highlight key changes in the proposal. So there's a little bit of additional time lengthening the adoption timeline. Under the proposed rule, it was as short as 1 year for large accelerated filers. And the final rule extends this timeline, giving LAFs, as they're shortened, 2 years to provide most disclosures, 3 years for GHG emissions information and certain other disclosures, 6 years for limited assurance on GHG emissions, and again, for LAFs, 10 years for reasonable assurance over GHG emissions. Another change of note, materiality thresholds were imposed on Scope 1 and Scope 2 GHG emissions, and I guess not to get too far ahead, but Scope 3 fell out. So not only is that off the table currently, but also these materiality limitations imposed on what is required to be reported under Scope 1 and Scope 2. So it's, I'll jump into this in a little more detail, but a materiality threshold for Scope 1 and Scope 2 disclosures. Again, timing intertwined with this, there's a little more time. So domestic registrants must provide GHG emissions disclosures and any assurance as the time they file their second fiscal quarter report for the following year, rather than in the annual report as originally proposed, so a little more time there. Another key point, there was a lot of discussion on how you define the organization for the sake of collecting data on all of these disclosure and reporting obligations. So some of the comments on aligning GHG emissions and operations with what is required currently under consolidated financial statements, concerns about the compliance burden of what's in scope for certain financial disclosures and others for climate-related disclosures. One of the proposals was seeing if there was alignment with a GHG protocol. And so the final rule does not require registrants to use any specific method for determining organizational boundaries, but if it does diverge from those used for consolidated financial statements, material differences should be disclosed. Again, getting back to materiality, there were perhaps helpful discussions and qualifications included on materiality, which I'll get into in the next couple of slides, or matters that are likely to become material. And for the last piece on the financial related metrics, materiality was originally proposed to be evaluated on a line by line, item by item basis. And some of the commentary included that it's too overly granular. It wouldn't really add anything. It would be very costly to implement and assess on a line by line item basis. And so in the final rule, the SEC modified this requirement so that registrants would only have to disclose financial statement effects and a variety of things that we'll get into if it exceeds 1% of pre-tax income or total equity. And as again, I'll get into in a couple slides, there's a de minimis threshold of $100,000 or $500,000. And so couple gating items to be mindful of that were included, likely in response to comments on burden and other concerns identified in the comments. Next slide, please. So regulation SK, as we've seen before, so these relate to periodic reports and registration statements. And so a few new additions, each of these probably could be their own 1 hour webinar, but a brief overview on some of, I think, the pillars or baskets or, whatever kind of shorthand you like to refer to these. So listed here, governance, item 1501. So there are requirements for disclosure of board oversight of climate-related risks and management's role in assessing and managing material climate-related risks. Under the strategy pillar, 1502, a requirement of disclosure of risks as well as impacts and whether these are being considered as a part of a company's strategy, including transition plans, scenario analysis, and internal cost of carbon for investment or other decisions. The third item, 1503, risk management, a requirement of disclosure on the processes used to identify, assess, and manage climate-related risks. The next item, disclosure of targets and goals, 1504. This is a requirement that targets and goals with a material effect on the company's business, the results of operations or financial condition must be disclosed, and they must be updated annually, including with what occurred in the prior year and what was done to achieve such targets and goals. On GHG emissions and emissions metrics, requirement again, scope 1 and scope 2, only to the extent material as further defined. And again, required for only large accelerated filers and accelerated filers. And the final point here, attestation, item 1506. This is, and again, will be phased in, but a requirement to obtain attestation and attestation reports covering GHG emissions disclosures. Next slide, please. So continuing alphabet soup, Regulation SX, these concern notes to audited financial statements. And 3 to highlight here on expenditure metrics, requirements to disclose aggregated expenditures as incurred or losses, including as a result of severe weather events, or what are referred to as SWEs. However, these do have a materiality threshold, so this is 1% measured against the absolute value of pre-tax income or loss, and also for this line item, expenditure metrics, has a de minimis threshold of $100,000. For the second line item, capitalized costs and charges, there is the requirement of disclosure of capitalized costs and charges incurred as a result of SWEs or the severe weather events. Again, subject to a 1% disclosure qualification, but for this, the de minimis disclosure threshold is $500,000 or 500,000. Excuse me, dollars. Last piece here, I know this is very popular and a very robust market that continues to grow in the US, but for carbon offsets and RECs, to the extent these are used to achieve or a material component of a company's plans to achieve climate-related targets and goals, these must be disclosed under the rules, including the aggregate amount of RECs expensed, the aggregate amount that have been recognized, and any losses associated with carbon credits and RECs. Next slide, please. So this wouldn't be a discussion of happenings in the US without talking about lawsuits. So within 2 weeks, probably 1 or 2 that have been filed, of course, as we've been giving this presentation, but litigation launched almost immediately, which was anticipated, to say the least. And so many of these, just very briefly, for those who may not practice in the United States, these went to administrative appeals from federal administrative actions. Typically, you can go to the DC Circuit or one of the circuit courts. And so these are intermediate courts, meaning they will be heard in one of those fora. And then if appealed, which they likely will be, that's where you go to the Supreme Court. So these are, we have 13 circuits, and these, perhaps unsurprisingly, although not outright directly stated, they draw from different areas of the United States, and so they tend to have different leanings politically and with judicial philosophies. So many of these line up as identified here. So Republican states sought friendlier fora, so 5th Circuit in Texas, 6th, 8th, and 11th Circuit, basically alleging that the SEC has no underlying authority to issue rules that extend to climate related risks, and so the entire thing should be scrapped. Environmental groups correspondingly went to areas where they have, I guess, a friendlier possible set of judges. So 2nd Circuit in the New York area and the DC Circuit, and their gripe is that the SEC should have gone further. It has an obligation to address material risks which can include climate, and so there is no need to not include Scope 3 amongst other challenges about how SEC should have gone further. And my reference to things sort of changing day to day for everyone who was part of this presentation, last Friday, March 15th, the Fifth Circuit issued a stay of the rules, which means the court ordered that the rules should be on hold until there is further procedural fighting, I guess you could say, to determine where the cases should be held, who should hear the cases. And so from the perspective of a regulated entity, this is not unexpected that this would occur, but it makes this an additional layer of complexity, which is the applicability of the rules, depending on these court decisions, may change. They may change based on the region that the court is in. So depending on the scope of the court's order, it could be put on hold in that circuit or across the United States. But fundamentally, the point here is that anything and everything about this procedure, substance, anything will likely be challenged, just given the interest at stake, both for and against these climate rules. And so fundamentally, just a couple quick takeaways, as may be obvious, is this is coming. It may be, depending on what is put on hold under the original deadlines that are announced in the rule, or there may be a couple of years or year where, just given the fighting in the course of litigation, some additional time will need to be added. But ultimately, the train has sort of reached the station, all aboard. For companies that are a little bit ahead, including those that have sustainability reports, and this is probably most of the Fortune 500, what will be, I think, devil meets the details on compliance is it's not the case that simply complying with EU will get you a pass in the US and necessarily vice versa. And so even companies that are relatively ahead will need to make a meaningful and concerted effort to adopt and adapt to what is forthcoming in jurisdictions in which they operate. Next slide, please. I'm just checking the time. I know we have a couple more minutes, and so I'll keep some of these other items a little shorter. And as Fabian mentioned, our contact information is here. Happy to take questions or discussions afterwards. But a couple remaining points here related to developments that, again, I'd like to tee up is that this isn't solely about the SEC, and this isn't solely about private companies. And so one of the pieces of this on the federal side, beginning of the Biden administration, there was an executive order outlining the administration's position on climate-related financial risk, the idea being that disclosure is important and the need to address disparate impacts on certain communities, disadvantaged communities, communities of color, would be a priority. And so therefore there would be actions that flow from this. So these are directed towards federal agencies and for federal programs. Next slide, please. So under the Federal Acquisition Regulations, or FAR, which is a set of regulations developed by the Department of Defense, NASA, and many other federal agencies, there was a rule proposed in November of 2022, which may come out shortly in first half of this year, I think, is anticipated. But this would apply. So unsurprisingly, a lot of those who are SEC registrants may be defense contractors or obtain contracts from the United States government, which likely would bring them within the ambit of this rule. But there are many other entities who are not SEC registrants that do business with the federal government. And so regardless of what camp you fall in, there's no sort of true alignment between what the SEC requires and what the FAR as proposed would require here. And so under the FAR regulations, depending on how they come out, but as proposed, it may require disclosure of Scope 3 emissions that are currently not required under the SEC rules. and the SEC rules would not necessarily require disclosure of science-based targets, but if they are set, the disclosure obligations under the SEC rule and the federal acquisition rules are different. So fundamentally, from this perspective, depending on how these come out, but the scope could be far broader in certain respects than the SEC rule, because anyone with, and as it's described, 7.5 million in government contracts are subject to a piece of this FAR proposed regulation, and those above 50 million would be subject to Scope 3 emissions disclosures. Rough numbers, there's about $700 billion in 2022 of federal contracts, and about 56% would affect small businesses based on current awardees. And so again, this is not all about the SEC, not all about private companies. And I think I will gloss over, Fabian, if we can maybe go to the second to last, just the continued ESG backlash point. As you probably have read, but just a couple of bigger articles in the US, there's been New York Times reporting on a lot of money is flowing out of ESG related funds. Republican legislatures in 20 states have passed rules largely restricting the ability of their pensions to invest in ESG related funds, and had a lot of chatter in the United States, a Wall Street Journal article on the dirty word of ESG. So I think the net of this is that companies continue or are required to continue looking at these topics. However, you know, some of these buzzwords come in and out and fall in and out of favor. And so much like politics at large in the United States, this is like anything else. There's been camps, there's been many hot button issues that flow out of this. But at the end of the day, I think companies, regardless of what they call it, at least bigger companies, have continued to commit to putting efforts into these, and obviously, as necessary, as required by law, need to continue to put effort into these. So Fabian, I don't know if we have any questions or can identify any, but I'll turn it back to you for the administrative closing piece.
Thank you, Alex. Yes, we received a few questions. I think we can take time for two very short questions. The first question is to Anke, and it says, Anke has mentioned the responsible contracting project. Who is part of this project and what is its background?
Yes, thank you. So very briefly, the responsible contracting project is an interdisciplinary team of experts who seek to establish a responsible contracting toolkit, and this aims at implementing 3 core elements which shall align contracts with due diligence obligations in the supply chain, given that the current contracting practices may sometimes well serve the financial interests of the companies, but not so much the environmental and ESG aspects. And so this aims at fostering a more balanced and fair contracting practice, which, if this is actually put into practice, will result in a substantial shift in the approach of how to draft and negotiate contracts. So I think this is really a very interesting project to be aware of and to follow.
Thanks.
I have one thing I would also like to mention, because this question came up a couple of times from clients, and maybe it's also here in the list of questions, but some clients have also asked us how, even if they don't fall within the scope now, but will be under the EU legislation, how can we get ready and get prepared? And I can only recommend, even though this applies only to the German Supply Chain Act, to take a look at the guidelines or the handouts offered by the German supervisory authority, which are also available in the English language, because they give you an idea of how to conduct, and that's something which can be done way in advance to carry out a risk analysis and implement a risk management system. And how this is done, there are some very good practical steps and suggestions how to approach this on the BAFA website. But if you have further questions now to Alex, maybe if there were some questions, but if you have any questions, please don't hesitate to contact us, and we will try to answer all your questions as quickly as possible.
Yes, there is another question to Alex, and it says, what are some of the legal theories that petitioners are arguing should overturn the SEC rules?
Sure. So I'd say probably everything and anything will be used and litigated in this matter. A couple that are sort of repeat players. We have at the federal level something called the Administrative Procedures Act, which, as the name implies, there are certain procedures that must be followed that many of these states are alleging have not been followed. Here, there's a few other theories, including that the net of it, called the Major Questions Doctrine, is that because this is such an important and far-reaching topic, that it shouldn't be left to a regulatory agency. It should be an authorization by Congress to further refine the scope of what the regulatory agency is allowed to regulate. And what is interesting, I guess, just to close out some of the bigger arguments, is an argument available to both sides, to everyone, which actually might be a way that this can be further developed without taking a substantive position, is the concept of the rules between proposal and final may have changed so much that there should be further opportunity for the public to comment. So given Scope 3 fell out, given that there were materiality limitations imposed on Scopes 1 and 2, just for example, the argument here would be too much has changed and everybody should get a chance to further comment, which, if that carries the day, would mean this regulation could be sent back to the agency, and then another year, another 2 years of more comments. So many different potential arguments, but to me that seems maybe the one most middle down the road of just, this is really important, so people should have more time to comment on it.
Okay, thanks. Thank you all for this insightful session, and thank you, dear viewers, for your attention. You will receive the slides and the recording afterwards in a follow-up email. After you leave the webinar, there will be a short survey, and we'd be grateful if you took the time to answer this short survey. If you have any questions afterwards, feel free to get directly in contact with our speakers. The contact information will be on the slides that we send you. And yes, then thank you for being with us today, and have a good day.
Yes,
Bye.
have a nice day, and thank you for attending once more. Bye-bye.
Bye.